Hello. In this video, we're going to discuss the case Marbury versus Madison, which established the concept of judicial review in the United States. Judicial review is the idea that the courts have the power to block a law or executive action that the courts find contradicts the Constitution. Today, this is viewed as one of the essential parts of the checks and balances system, but there are critics who argue that it gives courts too much power to invalidate decisions made by the elected branches. While this issue was discussed during the ratification debate, the text of the Constitution itself does not specifically authorize judicial review. Another key concept in this case is the writ of mandamus. This legal term refers to an order by the court to a government official, requiring that official to do a certain act as part of their job. A court would issue this writ when it finds that an official made a mistake and that the appropriate response is for the official to take some specific action to rectify the error. Finally, remember the term original jurisdiction. A court has original jurisdiction if it is the first court that would hear a case. That court would also be the decider of facts of the case. Any subsequent court that hears an appeal of the case would only have appellate jurisdiction and would not usually relitigate the facts. So how do these terms apply to Marbury versus Madison? Here are the facts of the case. In late 1800, the Electoral College voted to make Thomas Jefferson the third president of the United States, replacing John Adams. This would be the first time that a president would be succeeded by someone from an opposing party. Adams was a Federalist, while Jefferson was a Democratic Republican. The American system leaves a long time between the time the Electoral College decides on a president-elect and the time that that president-elect is sworn in. So Adams and the Federalist Congress decided to use that time to try to extend their influence over the federal government. They passed the Judiciary Act of 1801, which created new courts and new positions for justices of the peace, and President Adams appointed the people who would fill those roles with the Senate's approval. One small hitch in this plan is that since they were doing this right up to the last minute, they didn't get a chance to deliver all the paperwork. When President Thomas Jefferson came into office, he found a handful of commissions signed and sealed, but not delivered. Without those commissions, the newly appointed officials could not prove they had their jobs, which means, for all intents and purposes, they didn't have the jobs. So one would-be Justice of the Peace, William Marbury, decided to sue Secretary of State James Madison to demand his paperwork and thus his job. So what did the Supreme Court have to consider in this case? First, was Marbury entitled to the commission? Second, if he was entitled, what's the appropriate remedy? Third, did the Supreme Court have the power to deliver the appropriate remedy? What Marbury wanted was for the court to issue a writ of mandamus to Madison, ordering him to deliver the commission. Would the Supreme Court be willing to challenge another branch of government like that? And lurking beneath all of this is another question that Marbury did not ask the court to consider, but which would turn out to be very important to the outcome. If the Supreme Court finds that a law passed by Congress violates the Constitution, what can the court do about it? The court's ultimate decision was that, yes, Madison and Jefferson violated the Judiciary Act of 1801 by not giving Madison his commission. And yes, the only way that this error could be rectified was by actually giving Marbury the commission. Awarding him financial damages wouldn't work because that would be implying that a job like Justice of the Peace has a price tag, which the court didn't want to do. So a writ of mandamus would be the appropriate response. But the court said, we can't issue it. Hold on, what? Well, it turns out that Marbury brought his request for a writ of mandamus to the Supreme Court because the Judiciary Act of 1789 gave the Supreme Court original jurisdiction over such cases. But Chief Justice John Marshall pointed out that Article 3 of the Constitution says that the Supreme Court would only have original jurisdiction over a specific set of cases and appellate jurisdiction in all of the rest. Therefore, the Act of 1789 was trying to give the Supreme Court a power the Constitution said it did not have. And since the Constitution is a higher authority than a law passed by Congress, if the two conflict, the law has to give way. In this case, it meant that the Supreme Court had no power to take the case and could not issue the writ. So let's look at the judicial judo move that Chief Justice Marshall has pulled off here. He gets to lecture Madison and Jefferson about breaking the law. And from Jefferson's correspondence decades later, we know he was still cranky about that. But Marshall does not provoke a confrontation with the executive branch by ordering Jefferson and Madison to do something they have absolutely no intention of doing. And in the process, Marshall establishes the principle that the court can judge whether or not a law is constitutional. He establishes a precedent for judicial review. And even though Jefferson doesn't like that very much either, he can't really complain because in the end, he got what he wanted. He denied the last few Adams appointees their commissions. Now, the Supreme Court rarely used the power of judicial review to overturn federal laws after Marbury versus Madison. Presumably, they did not want to push their luck and provoke a confrontation. But in the 20th and the 21st centuries, the court has been far less reluctant. Many of the other cases that we'll study would have turned out very differently if the Marbury precedent didn't exist.